So we get a lot of questions from prospective clients wanting to know what's the difference between a consultant and an attorney when working with Amazon and suspensions and any other issues related to Amazon. What's the difference between working with a consultant, with law firms, and with you guys, with ESCO? So I thought we would create this helpful chart, and hopefully this could help explain. So the first thing that we could discuss is attorney-client confidentiality. By law, attorneys are required to maintain confidentiality, meaning anything you tell your attorney or their staff, their office, has to be kept confidential. They can't go out and tell your secrets to anyone else, and most of the time they can't even mention it to other people working on the case unless they have your permission, right? Such as experts and all that. So that's one of the main differences between working with a consultant and with a law firm. And why would that be important? Sometimes when prospective clients come to us, they may not want to tell us the entire story until we sort of assure them that, hey, there's confidentiality, and by law, we're required to maintain this confidence. So that's one of the main differences. Second thing is a conflict check. Conflict check is something that's done by attorneys, by law firms. And the reason we have to conduct this is to ensure that we don't represent two opposing parties. Now, most of the work that we do is against Amazon, and since we don't represent Amazon, that's really never the issue, right? However, let's say that we have one seller who's got issues with another competitor. And in that situation, we wouldn't be able to help the other competitor, sort of help both of them fight against each other, because that would be a conflict of interest. And all attorneys have that statute, have that duty to maintain conflict of interest, right? So make sure that there isn't a conflict of interest, and to ensure that, we always do a conflict check. So anytime you come to our law firm, we'll go ahead and see who you're fighting against, or who is on the other side, who's the opposing party, and we'll conduct a conflict check. That's something that's done for every prospective client that comes into our firm, and hopefully other firms are doing the same thing and have systems and processes in place to do that. The next thing is government oversight agency. So consultants really don't report to anyone, right? Where with attorneys, we have the bar, and the bar, each state has its own bar. For example, here we're barred in Washington State, where Amazon is headquartered, and California, and also able to practice in front of the USPTO, the United States Patent and Trademark Office. But anything we do wrong can be reported to the bar, right, of the respective state. And it's not just us, but any attorney. And that's one agency that I promise you all attorneys are respectful of, scared of, right? Because they just want to avoid any dealing with them. Anytime you're under investigation from the bar, or the bar is auditing your systems and processes, it's a nerve-wracking time. So that's what attorneys have. That's what law firms have, is the bar that they're registered in. But consultants don't really have anything like that. So if you wanted to report, let's assume that you worked with consultant ABC and they did something that you feel was completely wrong, and you want to report them, there's really no agency that oversees their activities to make sure that they're following a certain set of guidelines or rules, right? As I said, attorneys, there's volumes and volumes, pages and pages of statutes and responsibilities that we have to abide by when we're representing clients. Next thing is IP attorneys on staff. And here, for consultants, I put a no that doesn't apply, or they don't have attorneys, IP attorneys. And for other law firms, I put a question mark, and for ESCO, I put a check mark. So IP attorneys meaning intellectual property attorneys, right? And even though you may be dealing with an attorney, they may not be trained or specialized in IP law. Here at our firm, we do. So that's why I put a question mark for other law firms. because it would really depend on who you're dealing with. But that's one of the questions that you should ask is, are you guys an IP attorney, right? Do you guys specialize in IP? And obviously that should be on their website and in their marketing material too. I don't think anyone is going to hide the fact that that they're an IP attorney. What you don't want to do is deal with attorneys that specialize in other areas. If they're focused on PI cases or personal injury cases, meaning car accidents or slip and falls, you don't want them dealing with your Amazon matter, right? And we work with a lot of large clients. Some of our large clients are pharmaceutical companies, and they have an army of attorneys. But when it comes to dealing or working with Amazon to resolve their issue, their army of attorneys isn't really trained in dealing with Amazon, and that's one of the reasons that they hired us and continue to hire us. So that's one thing you want to ask is, do they have IP attorneys on staff? And obviously consultants, they don't have attorneys, so that would be a no for them. Next thing, responsibility versus liability, right? The strategic wording. This is something that doesn't get talked about a lot, but I think it's super important. So we all know that with POAs and with appeals and escalations, when you're dealing with Amazon to get your account reinstated or ASIN reinstated, most of the time they want you to accept responsibility, right? But that doesn't mean that you have to accept liability. And there's a huge difference between the two. Liability or accepting liability is liability is a responsibility, a legal responsibility you have. So like a legal duty that you have, right? And if you didn't abide by that duty or you breached that duty, then you would be liable. That's completely different than responsibility. And it's very subtle, but for attorneys, it's night and day. It's a huge difference. So that's something that I, from my experience, looking into our other competitors or other people, other consultants in the same Amazon space, I know that most of them really aren't focused on that. And why is it important? Because anytime your matter is escalated, or God forbid, if you have other issues later on with Amazon that results in arbitration, I promise you their attorneys are going to pull these up. And we've had this done in arbitration where our clients had hired consultants or other law firms, and they weren't careful with how they worded their POAs. So they sort of took legal responsibility with some of the issues that had come up, with some of the violations that allegedly they had done. So very subtle difference, but that's something that me and my entire team, I've trained all of my team members to sort of ensure that we're wherever we need to, we're accepting responsibility, but we're not accepting and we're not putting down on paper that we are legally responsible or liable, right? So that's something very, very important to know. Again, very, very subtle. And you may be okay with running your business for the next 10, 15 years and never have this issue come up. But I promise you, anytime you're in arbitration, it is very, very likely that the other side, that Amazon's attorneys will pull up your POAs and say, on this date, you said this is what you wrote, this is what you submitted, where you said essentially you were in the wrong, you were legally wrong, you were legally responsible. So something to be very careful about. And one of the examples that I wrote down is, instead of writing that you violated this policy or you infringed this this trademark, you could write something. We do is we could write allegedly violated, right? Just that one word can make the world of a difference. So that's strategic wording. And I'm not sure if other law firms are doing that. I hope they're doing that. But I know that our law firm is doing it. And for consultants, at least the POAs that I've seen that were drafted by them, I didn't see it in any of them. That's why we put that red X there. And then we put the question mark for law firms, because with some law firms, I did see it. I'll be honest, I'll be fair. With some of them, I did see it. I don't know how consistently it's being done, but I know that I saw it. That's why we put a question mark there. Next, licensed and registered in Washington State. So Washington State is where Amazon is headquartered. Now, why do you want your attorneys registered and barred and licensed in Washington State, where Amazon's headquartered? Well, according to the BSA, which every Amazon seller signs, the laws that will be used in interpreting the BSA, the Business Solutions Agreement, is based on Washington law. So about a year and a half ago is when I got barred and registered and licensed in Washington State. So now legally we're able to practice Washington State law. I've talked to several other attorneys in our same space, and I don't think any of them are barred or registered over there. But I know that we are. And now obviously consultants, we put a red X there. They're not attorneys. So again, they don't have that government oversight agency. They don't need to be registered or barred anywhere, and they can't really. Next thing you want to look into is arbitration experience. And arbitration with Amazon is through the AAA or American Arbitration Association. Now, with consultants, I don't know of any that have experience there. I may be wrong, but I haven't come across any. With other law firms, there are several of them that do have arbitration experience, as do we. But that's one thing you want to look into. It's always important for Amazon's attorneys to know that the attorney representing you has arbitration experience, has taken Amazon to arbitration and prevailed, or has taken Amazon to arbitration and forced a settlement, or they've decided to negotiate and settle the case, right? That's very huge, especially with more complex matters. So you want to make sure that they have experience with AAA arbitration. Next thing, where I don't know if anyone else, other law firms or consultants are doing, is a legal analysis. So this is something we do early on in representing you. One of the first things we do is do a legal analysis. And what do? Once we gather all the information from you, we want to take a look at what Amazon is alleging that you did wrong, and then look at their policy, Amazon's policies, and find all the relevant policies and guidelines and put it together and sort of have this confidential communication between us and you, where no one else can see this letter, but letting you know what we think of the entire situation, taking an unbiased approach, an unbiased view, and saying, look, Mr. Client, or look, Miss Client, here's what you did based on our understanding, based on the facts and documents you provided us. Here's Amazon's policies and guidelines. It's our opinion that more likely than not, you probably breached it, or you didn't breach it, or you didn't violate it, right? But here's our chance to educate you, to have you understand what Amazon is claiming that you breached or you violated, so you understand, and you can also train your employees, your staff, about what was wrong and make any changes in your business that you need to. So that's a legal analysis. That's something that we give to you guys. Again, completely confidential. No one else sees this except for you. But our goal there is to educate you and sort of inform you about what Amazon's policies were and what you allegedly breached or didn't breach. So that's something you get. And again, for educational purposes only, completely confidential. Amazon will never see that. Based on whether we, in our biased opinion, we say that you did violate Amazon's policies or you didn't violate Amazon's policies, that doesn't change the way we advocate for you. We still have a legal duty as attorneys to zealously advocate for you. So that doesn't change any of that. This is just sort of, imagine us pulling you into a corner and saying, hey, here's what I think you did wrong, right? Or here's what I think you did wrong. So the next thing, ongoing legal support. Now, what is this? One thing that we offer for all of our clients is once a month, we have open office hours, and it's usually me or one of our other attorneys. They'll jump on for, I think we're doing 2 hours or 2.5 hours now. So once a month on Thursdays, we'll jump on and just be available for any of you guys to come in and ask us questions. We don't bill for this. It's just our way of making sure that we're there for you guys when you guys need anything, and you guys don't have to pay anything. So it's a nice group setting for us to help answer any non-confidential information. Okay, so that's ongoing legal support. In addition to that, what we started doing is what we have is called a Team 100 list. And this is a list that we don't We don't publish anywhere. We don't even provide to our clients, but it's an internal list. And it's a list of vetted, reputable, trusted vendors, whether it's a freight forwarder, whether it's a CPA, whether it's an accountant, or other attorneys, such as like a trust and estates attorney or a personal injury attorney. So that's a list of people that we've already vetted, and we can recommend. So if, for example, I think it was a week ago, one of our clients was looking for a CPA, and we looked on that list and made a recommendation, a warm introduction, introduced our client to the CPA. So that's something else that we offer, not really legal support, but ongoing support. And again, we don't bill for any of this, just to ensure we're continuing to help you guys succeed in your business, right? It's, to be quite frank, it's a bit selfish, obviously, but it also is a benefit to you guys. We want to make sure we're there for you guys, and you guys always remember us, right? But you guys are getting something out of it and not paying us anything for it. So I think it's a good exchange. Next thing you would look at for attorneys is that they haven't been suspended or disciplined by the bar. Again, this is going back to the government oversight agency, the bar, BAR. Every state has it, and wherever your attorney is barred or registered in, you could go look them up. But this is public information, and you want to make sure that they haven't been disciplined. Obviously, for consultants, I put a question mark. Really, probably should have been an X. I guess the reason I put a question mark is maybe you could look up the Better Business Bureau to see if they've had any complaints. Other law firms, I put a question mark because one of the attorneys in the space has been suspended and has been disciplined, and that's why I put a question mark, but most of them haven't. And this is a real serious matter. It's real serious when your attorney has been suspended or disciplined. Usually it'll be for fraud or something really, really horrible. For us, we've never been suspended, never been disciplined, so I put a check mark there. But that's something you want to ask when you're working with other law firms, other attorneys, is have you ever been suspended or disciplined? Or you could just look it up yourself on the bar's website. Next thing is synthetic arbitration. Now, I put this there, but that's a service that we only offer, right? It's proprietary to us. It's trademarked. I should have had R in a circle. It's trademarked by us. It's synthetic arbitration, or SynArb. But this is the escalation right before we actually go to arbitration. So in our previous videos, you'll see that arbitration is going to cost a lot of money. It's going to be very time consuming. So we created synthetic arbitration sort of in between internal appeals, POAs, dealing with Amazon's internal teams, and an actual arbitration. So we came up with synthetic arbitration. This is like pre-arbitration, where we'll work with Amazon's outside legal counsel. This is a law firm based out of Washington State. Another reason why we're barred and registered and licensed in Washington State. But we'll deal with Amazon's attorneys up there. It's a law firm called DWT, Davis Wright Tremaine. And we'll work with them. We'll send them, obviously we'll do our due diligence, take a look at your case, and then draft a demand letter to them saying, here are the facts, here's Amazon's guidelines, here's Amazon's language with respect to the BSA and what we can and what we can't do. And here's why we think we deserve XYZ. And that is what we demand is XYZ. And then they'll do their research and then get back to us. So this is a law firm that we work with on a daily basis. Our law firm works with Amazon's law firm, DWT, on a daily basis. And that's something that we only offer. But you want to make sure that you're working with a law firm that at least has something in the middle, right? And as I said, synthetic arbitration, something that I love, and it's done miracles for people. People have come to us where they've tried 3-4 other consultants and law firms, and they've been unable to get any results. One of our larger clients, for the last, well, they were suspended about 5 years ago, and they tried consultants, they tried other law firms, and essentially they had given up. We were helping them with other matters. And then finally, once we were able to help them, they asked us, like, we've got this other issue. Like, do you think you would be able to help? I said, let's try synthetic arbitration. I don't see why not. Obviously, there's no guarantees, but I don't see why not. So we tried it, and after 5 years of being suspended, they were reinstated. Their Amazon Seller Central was reinstated, and this is a very large client. So it's done other miracles such as inventory reimbursement for a few $1,000,000 from $20,000 to $40,000 to a couple $1,000,000. So synthetic arbitration, that's something that only ESCO offers. So very proud of it. And like I said, it's done wonders. It's really been a miracle for Amazon sellers. So those are the 10 reasons to choose us, to choose ESCO. And if you guys need anything, you can go to our website, esqgo.com, or call us at 424-363-6233. All right. Any questions? Let us know. Thank you.